we're trying to change the typical way that people think about getting what they're owed. It understandably, it used to be just like, how the hell am I going to do this? Like, do I even want to start that whole process? And we just want to convey that it's actually, at this point, at this time in our country's history, you actually have a relatively simple way to get back what you're owed.
You are listening to Power Marketing with Kevin Lee. Kevin and his agency Did It have helped thousands of businesses win through superior marketing, as have his books, articles, speaking engagements, and the E-Marketing Association Power Marketing podcasts. Here's Kevin.
I'm super excited to be here today with Michael Egenthal, who started a company called Squabble, which is all about finding ways to get paid when somebody's not paying you and they owe you money. So, Michael, I'd love to get from you the origin story for Squabble, because you essentially invented something that doesn't exist for a lot of folks.
Right. Yeah. Thanks, Kevin. Appreciate it. This is super fun. Excited to launch a series of these. My name is Mike Egenthal. I'm an attorney in California. I teach law as well. About 5 years ago or so, a student of mine and I were in the bowels and the depths of a law school in California, University of San Diego, and we just started. We were going through some exercises, some law school class stuff, and we just started musing. We went down some rabbit hole, and we were like, "How many times has someone owed you money, and you were like, I'm going to take you to small claims, right? How many times you heard someone say, I'm going to take you to small claims? And like, how many times have you actually ever done that, right? And we started thinking, like, how many people then actually are owed money and never actually get their rights vindicated? Because you don't hear much about people actually going through the small claims route. They usually just give it up, just give up the issue and move on with their lives. So we started doing some research. We started asking other law professors, attorneys in the field, and then did some market research, and we found some crazy figures. What we found was basically, yes, there are 3.5 million lawsuits filed in small claims per year, and the small claims range is usually somewhere up to 10 grand, something like that, depends on the jurisdiction. But the crazy figure that we saw was there are somewhere in the range, this is a broad range, but 60 million to 120 million cases where someone's actually owed a monetary sum of up to 10, 15 grand, and they didn't file a case, they didn't vindicate their rights, and they just dropped it. And so that was the genesis of Squabble, and we're thinking, all right, can we be of some service there? Can we come up with some creative solution to help those folks?
Yeah, that's a great origin story, and the fact that you sort of removed a lot of that friction is key, right? Because most people are not going to be doing a lot of small claims filing. They'll probably just do one or two. Of course, businesses may need to do them more often because they tend to get owed money a lot. I certainly know for us at Did It, right? We've certainly had folks who've either chosen to try to not pay us or just not paid us sometimes because they're going belly up. And the same is true in the marketing and advertising ecosystem, because you got folks who sell advertising like newspapers and radio stations and whatever.
Right.
They got folks who don't pay. You've got freelancers who do freelance work, and then the agency doesn't pay. And then you've got agencies who've got clients, and the clients don't pay. And for us, now that we're bigger, usually the amount is like over 10,000, and it's often big enough where we can think through, like, oh, maybe we'll have a collections team or a collections attorney do the work. But as you move into the down market and local media companies and freelancers and smaller agencies, I'm sure there's just a ton of folks in there in that mid zone where it's sort of not big enough to go out and hire a lawyer or hire you, right? In the case of out in LA, so they're not big enough where they could hire you, but it's sort of big enough that they care, right? And then it seems like that would be the perfect thing to do. So how should a person go through this thought process of, should I do small claims? Should I hire a lawyer? Like, how should I get myself paid?
Right, I got you. Yeah, and it's good to be educated on some of that in your particular industry, in the marketing industry. We always appreciate learning about the particular industries where we have cases coming from all sectors, obviously, of the economy: contractors, roommates, landlords, tenants, personal loans, consultants. And so it's interesting to hear that from the marketing industry perspective. It's, obviously prior to Squabble, prior to having a service that you could do this in in the time of 6 minutes, it's understandable why folks wouldn't do this. I mean, who the hell wants to figure out what paperwork to get for your particular jurisdiction? What is your jurisdiction? What paperwork to get? What forms to file? Are there extra forms? What do I have to say in this line in the form? Which within that jurisdiction, which courthouse, which clerk, all these types of things. You want to run your business, right? You want to service your customers. Nobody wants to figure this out. That's why people, we're not vindicating their rights. Or not. Even they say screw it. All right, I'll let it go. It was $3,500. What am I going to do? But nowadays, it's a lot easier. In the past, it was understandable. Okay, maybe you hire a lawyer in situations where it's on the higher monetary range of small claims, but on the medium to lower amounts, it just didn't seem worth it. I guess it comes down to what do you want a lawyer for, right? Like I think there's three things that you might seek from an attorney in this situation, right? Maybe you want to go into their office and you want to be like, hey, do I have a good case, right? And maybe you want to be like, all right, well, will you help me file my claim and help me with service of process, which is notifying the defendant formally, which is required by law. Will you help me with the paperwork? And the other one is, can you go to court for me, right? And so which of these, are you allowed to do? Which of these should you do? And sometimes that's not always clear. And I think it would be helpful, if we went into a little bit of a discussion about each one of those questions, to see what your best option is, in your industry and others.
Yeah, absolutely. I mean, I think a lot of folks who are realizing when it's like 90 or 120 days or 200 days, 300 days, like you're just not getting, it's coming up on a year and you're not getting paid. At that point, you sort of have to decide, what do you do? And a lot of times I think in my personal history and the history of other folks I've talked to in my industry, like the first thing they just want to do is scare the person into thinking that I'm really going to come after you. So I know that there's some things that Squabble does to perhaps help the person in that stage of their process, where can you sometimes just scare the person into paying you, right? Where might not have to go through the full filing process. And how often does that work? Like, because sometimes people will hire a collections attorney just to get the scary gram message letter to go out on letterhead, right? And so how often does something like that work versus actually having to go through the rest of the filing process? And how should people think through their stages? Okay, first I want to try to scare them, and then I'm going to legit file.
Yeah, I mean, I think it starts with, like anybody says, do I have a good case? And what we find is in small claims, if you're thinking about doing this process, you got a good case. The reality of it is 50%, this is what's crazy about small claims, 50%, half of the defendants that are sued in small claims simply don't come to court, which means you win automatically. A plaintiff wins the case. They get what's called a default judgment, and that is good for 5 years. Once you have that judgment, you can renew it for 10 years, and you can collect. So half of the time, they're not coming. The other portion of the time, just giving Squabble figures, for instance, the other half of the time, we actually find that 95% of our litigants either win by either default, or they win on their case by explaining it to the judge, or they settle before court. And so it's when you're concerned about, do I have a good case, it might not be worth it in the small claims realm to pay several $100s an hour for an attorney necessarily to look at your case. Of course, everybody has their own prerogative, and maybe the higher end disputes or ones that are cases that you might think you're uncertain of whether you're owed, that might be beneficial to hire an attorney. But in most cases, that's not really necessary. What'll happen when you go into an attorney's office in these situations is they'll be like, all right, yeah, we'll here's what we'll do for you first. We'll write a demand letter, right? What's a demand letter? It's exactly what it sounds like. It's a letter where, it has the letterhead of some attorney, and it says, we demand that you give us what we're owed. And if you don't, then we're going to file a lawsuit. Attorneys will do this for you. Perhaps some more ethical attorneys will say, hey, you can just do this yourself. And the reason is because a letter from an attorney and a letter from you, if well organized and written in an organized and professional fashion, they have the effect of getting the process going. But let's be honest, the statistics tell us that almost nobody's responding to a demand letter, and that's what we find. So it's not worth it to pay an attorney necessarily to do that. We would advise that you don't do that. And of course, Squabble offers on our website just a free demand letter that you can enter your info and it'll be tailored to your case. If we think that's advisable. It is advisable to start with a demand letter, but just don't expect that that's going to be the end all be all and you'll automatically get paid back. And the question then becomes, all right, what do you do then? Right? And the next step, I think, would just be getting the paperwork prepared, because what we find is the better way to scare someone into getting your money back, if you don't want to file in court, is have the demand letter, but also have the court paperwork just prepared already. So if they get the demand letter seriously and professionally written, and they have the actual filing, you haven't filed it yet, but it's ready to go, they're going to be like, okay, they're on the cusp. I'm on the cusp of being sued, And so we find that a lot of settlements occur at that point, and then you don't even have to go to court, which is amazing. You don't even have to file through Squabble or anywhere else. So that's a great option. And then you could also just go the route of, if they don't respond to that, then obviously you can file in court, and you can file in court through yourself, or you can file through Squabble or some other service. But there are various steps that have to occur, in filing a case, and you have to make sure that they're all done. And so doing it yourself is a little bit daunting. So that's why we created Squabble. If you Squabble, then you simply have the entire thing done for you, all the way from submitting through your court date, and you just sit back and get email updates along the way. Right.
Well, it sounds like the kind of thing where it's having sort of one's day in court is sort of both rewarding psychologically, but also monetarily, right? You do get to have your day in court that way, and feel like you took it to its final stage, right? One way or the other.
Exactly. And look, this is not a venture where you're spending an arm and a leg. I mean, let's be honest. The costs for our service are relatively inexpensive, and it's a way to not spend an exorbitant amount of your money trying to get back what you're already owed money. So you don't want to spend more money incurring another debt. So yeah, it's an inexpensive way to actually vindicate your rights, which is rewarding, and it's nice to get your money back. And what's great about small claims court is that actually when you file your paperwork, you're able to ask for your fees back. So anything you spend on this, like either Squabble or some other service, and your filing fees and court costs, the judgment will reward that back to you. So there's little risk there.
Yeah, that's fascinating to know. I certainly know, as I mentioned, in the media, advertising, marketing industry, there's a lot of situations where bills are not paid. Sometimes they're not paid because they shouldn't be paid, but a lot of times they're actually owed. But what other industries are you seeing across the sort of Squabble customers where you tend to see the same folks coming back around again, either from the same industry over and over again, or sometimes maybe the same customer having to, not get paid yet again, where they need to go through the small claims process?
Yeah, no, it'd be interesting to learn even more about folks in the marketing industry that have honest debts in this monetary range. I love peeking at the Squabble dashboard from time to time, because I love seeing the variety of cases that we get. It really runs the gamut. We obviously, as you mentioned, we have individual squabblers who file once, twice, 3 times in their lives. And then we have businesses where it's a regular occurrence because they have They're constantly having debts of, folks who owe them money. So small and middle-sized businesses of any types, contractors, electricians, plumbers, HVAC folks, anybody, any subcontractor who does a job and doesn't get paid, or maybe someone who had a job done for them by a contractor and it was substandard work, or they didn't finish the work. Landlords, tenants, property management companies, consultants of all types, puppy breeders, you name it. The other side of the aisle is the individual plaintiff who, we love these, is finally able to sue the big corporation. This is what gets really fun when we see the cases coming in. Obviously, Squabble is not an advocate for any of our plaintiffs, but it is nice to see that if you're, typically in life, we think that when we have a gripe against a corporation, a large mega corporation, your airline, a travel company online, your bank, what are we going to do? We call customer service and we reach a dead end, and then what are we going to do? Go to a lawyer? And so, we do see a lot of lawsuits against large scale companies. And the funny thing about those is they're nearly always successful because two things will happen. One is the corporation will not send somebody to represent them, so you'll get a default judgment, automatic judgment. And the other one is they'll typically just send you an email or a letter saying, okay, we'll give you this amount, and drop the lawsuit, which is nice.
Yeah, that's actually the fascinating side, is that you're sort of whoever the aggrieved party is, right? You're able to help them, right? And I certainly know that consumers have this idea like, well, it's American Express, like what am I going to do? Or it's somebody big, what am I going to do? But the idea, people usually think of small claims court in a way that they saw on TV with the old shows People's Court or whatever, right? They thought it was always the individuals and the barking dogs and the sort of silly cases that made it their way to TV. But it sounds like a lot of these are really just legitimate, situations where somebody wronged somebody else or owes somebody else money, and there's a process to get at it. So
it's just different now. It's just different now. I think, and it'll be nice for more and more people to understand that, in the past, there really wasn't too much of an avenue for you to go after what you're owed and have it be an actual serious pursuit where you were able to collect in a reasonable period of time. Now there's actually a legitimate way, and it's not going to take too much of your time to be able to do so. We've all called the customer service line and been bounced to 3, 4, 5 different departments, and only to find out there's nothing we can do for you. It's nice whether you're an individual or you have a company where you're owed money by a customer or a supplier, to have an actual route that's legitimate to go get what you're owed and have it not take up too much of your attention and time and resources.
I know in the cases where I've had to litigate either personally or corporately that, when I've had legal counsel advise me, they've sort of been able to take me through this process of preparing. Like, what are some good tips if you're going to do small claims, either as an individual or as a business, and sort of getting your ducks in a row, getting your stuff prepared, and what stuff should people have at the ready, right? Either when they're going to go through the Squabble process, right, and have a bunch of forms to fill out online, where they'll be guided through it, or whether they were going to have to litigate otherwise. Like, what should you have at your fingertips before you go through this process?
Yeah, I mean, so that's what I was saying earlier. Historically, you're going to go to the courthouse and get several forms. You can ask the clerk for several forms to fill out, and they can't help you. So they might refer you to maybe a small claims assistant that's there in particular hours who can help you fill in the paperwork at an appropriate time. They might, and hopefully they'll be able to tell you, where to file them, which part of the court to file them in, and what follow-up steps you'll need to do, because you'll need to file the paperwork, yes. And and then you'll need to serve process on the defendant, which is formal notice, and there's specific rules for that. And then you'll need to file proof of that service. There's a few other steps after the filing process. So that's why we wanted to do this with Squabble, so nobody has to care about any of that, once they submit. But once the case is indeed submitted, it's time to prepare. The great news is this: small claims court should not be intimidating to anyone. It is, it's one of the things that's most rewarding that I see from our users, at least, is, wait a minute, I went to small claims. I was there for, I talked to the judge for 5 minutes, and it was not formal. You still want to be presentable, but it's not a formal process. In fact, half of the jurisdictions and an ever increasing number are just doing Zoom hearings now. So you might never actually have to leave your house for the entire process. But in anticipation of your court date, you'll want to make sure that you have your paperwork, any evidence of what occurred, and proof, so that you can can hand it to the judge or digitally send it to the judge. And if you want, you can bring in a witness who has knowledge of the situation, who can attest to the fact that what you're claiming is indeed true. Be professional, be organized, be presentable, and be respectful of the judge. Again, this is not a complex formal environment, so you don't need to be worried that it's some big thing you're entered into. But just be well prepared with all of your evidence and calmly explain your position. You don't need to lawyer. You don't need to be, you don't need to know anything about the law. You just need to explain what occurred in a respectful way. And the great news about small claims court is all you have to be is 51% convincing. That's the standard. In a criminal case, in order to be convicted of a crime, the prosecution has to be 95% convincing to a jury of 12 people. Otherwise, you're acquitted and you're going home. This is the far other end of the spectrum. If you're 51% more likely than not convincing, you get a judgment.
And that's if they show up. And if they don't show up, it could be less.
Yeah, exactly. And look, we're not trying to flood the courts with litigation. That's not what we're trying to do. We're just trying to provide a way for the small business owner, the middle-sized business owner, the consultant, the individual to be like, look, I'm owed this money. It's a few grand, 6 grand, whatever, 3 grand. I need that money, or I'd like to have that money because it's mine. So that's it's a nice option to have these days. We're not trying to flood the courts, because in many situations, defendants come to the table because as we discussed earlier, they don't want to go through the process either, so they'll extend the settlement offer out to you.
Right. Yeah, actually, that brings to my next question, which is obviously, neither side really probably wants to show up in the court, whether it's a Zoom court or a real court. And so they just want to come to some kind of an agreement. And, split the difference is sort of an arbitrary thing. One of my favorite books is Never Split the Difference, which is really more along the lines of, no, it's probably not right in the middle. It's probably
exactly
somebody who's more right and somebody who's more wrong, or more willing to pay or less able to pay. And so any tips as far as if the person does come back to the negotiating table, how should they approach that? Obviously it can sometimes be an emotional issue, right? For the person, especially the person who feels like, they were given the runaround, right? And so how should they go through the process of settlement negotiation without legal counsel at their side, right?
Yeah. And, I'm an attorney. I have many friends who are attorneys. I got nothing against attorneys. I'm just saying, I just want to convey to you, someone needs to convey to the working person, the business person, the business owner, this is not the realm of attorneys. It's not necessary. And there's a variety of reasons why. You can do this yourself. So if whatever way you file through, if you file the case, the defendant knows about the dispute, or you've sent them the demand letter with the prepared paperwork, and the defendant comes to the table, it's like, okay, well, let's say you're owed the full amount, You want everything you're owed. Understandably, that's what you're owed. And you have to ask yourself, what's it worth for me to just drop this process right now and take a certain amount? And, that can't be answered, in the abstract here. We can't set any sort of bright line or rule of thumb necessarily as to what you should be. It's a personal decision. But what the factors that you want to weigh, though, are, all right, well, what is their offer? What percentage of what I'm owed are they offering? How much more do I want to, how much more energy do I want to expend in this process? Do I want to go through and go in front of the judge and convince the court, or do I really just want to avoid that? Is the principle of it really important to you? And if that's the case, you want to get a judgment and you want to set some sort of precedent going forward that folks are required to pay, what they owe you. Those are all factors that you might want to consider. Of course, I always default in my practice to pro settlement, but I think settling is great. Get it over with, get it done informally, get your money, move on with your life. But both routes are available to you.
Great. So what happens if you win? So what happens if you get the judgment in small claims court? You take it all the way through, you win, you get your judgment. Then what happens?
Yeah. So defendants are required by court order to pay. That's what a judgment is. And you obtain a piece of paper that right then and there from the clerk that says you have a judgment. They are required by court order to pay, and it's mandated. If they don't pay, they're in violation of a court order. A good percentage of defendants will pay because they know they're violating the law if they don't pay. Other defendants, it might become an issue. Good news is you have 5-10 years where your judgment's good. At any point, you're able to collect from that person. Obviously, we don't want to wait that long. And so we want to wait for the defendant to pay voluntarily. And if they don't, there are ways to get paid back on your judgment, and they're relatively easy. It's one form for each of these processes, and I'll just list a couple of them. This is in the chance that they don't pay, but typically in a business context, like a consulting context in the marketing field, something like that, you'll have defendants who don't want to develop the reputation of someone who just, first of all, didn't pay, and second of all, didn't even pay on a judgment. But if you're in a situation where they don't pay, one of the options is they can garnish one piece of paper, and the wages of that person can actually be garnished, or they a one-page document, and their bank account can actually be levied, or a lien can be placed on their property. These types of things can occur with a relatively simple process through the court, or even some states allow the person's driver's license to be suspended with a DMV until a judgment is paid. These types of things. I recommend checking out on squabbleapp.com. We have a list of guides on a variety of these topics, but one of them is how to enforce your judgment in the event that a defendant doesn't voluntarily pay.
Oh, that's great. And obviously in the legal world, you have to keep everything confidential, but are there any sort of success stories that you found that were particularly entertaining or inspiring that you're able to share anonymously with us?
Everything's confidential and anonymous. There is complete privacy. When it comes to Squabble, we're ridiculously militant about complying with the ethical rules of professional conduct in all 50 states. But we can talk in vague terms, I guess you can say. Obviously, the vast majority of Squabble cases are serious situations where a business person just genuinely wants to get their money back, or a tenant wanting to get their security deposit back, something like that, or a personal loan. We have a lot of roommates that bolted, out on their roommate, friends who loaned each other, didn't pay back. I'll give you a couple. I'll start with one with a slightly less sympathetic plaintiff, and then we'll end on a positive note. We had a guy who sues a strip club in an unnamed city. He claims they ran up his tab in their bar and grill, and they said he paid for private bottle service, something along those lines. And he says, I got hustled, and I never actually spent the money, and he sues the strip club. And he went off to court, and there actually was a settlement in that case. So, on a slightly more sympathetic plaintiff note, we had an elderly woman. She had 7 cats, and she lent her cats, or she had someone pet sitting, basically, watched her 7 cats while she went away on her first vacation in 10 years. She left the cats in that person's care, and the person sold them while she was gone. And so we actually had this woman, this elderly woman, assisted by her daughter, file through Squabble, and she was able to collect on the value of the cats and actually some additional emotional damages compensation as well. So that was nice to see. Another sympathetic plaintiff. I just want to, I think it's fun to recap this one. Unfortunate for the plaintiff, but ultimately rewarding because of the result. We had a Squabble plaintiff. A gal was in a relationship with a guy. He said everything that she wanted to hear. He told her everything she wanted to hear about how beautiful she was and how wonderful she was. And then some time passed, and ultimately he started asking for her money to pay his bills. And then once his bills were paid, he dropped her, and he told her she was too fat and too ugly, and then quit talking to her altogether once his bills were paid. Well, what happened then? She filed through Squabble, and she got the money back from her bills that were paid, and all of her filing fees back as well, plus interest. So that's just nice to see plaintiffs actually get some, not revenge, but a way to take justice into their own hands in a way that's pretty simple and understandable to the average person. So those are a couple of them. We have some even crazier ones, but I'll leave those for another day.
Well, I think the point that I take from that is that, if the first person feels strongly that they got screwed, right, and it's in that zone, right, that in their jurisdiction is the small claims zone, they should absolutely go ahead and go through the trouble, right? Because they just got to convince the judge, if it makes it that far, that they got screwed, and they can end up on the winning side.
Yeah, and we're trying to change the typical way that people think about getting what they're owed. It understandably, it used to be just like, how the hell am I going to do this? Like, do I even want to start that whole process? And we just want to convey that it's actually, at this point, at this time in our country's history, you actually have a relatively simple way to get back what you're owed.
Yeah, I mean, I would imagine most countries don't have a small claims system, right? And that we're lucky enough to have one, and it's I guess it's uniform in every state. And is it the jurisdiction made statewide, or is it county specific? Like, is it pretty similar, across the United States, or are there a lot of different?
It's not, and that's why it took a while. It took about 3 years for Squabble to be coded out nationally. So if you're a plaintiff in any state, you can use Squabble. Small claims is very localized. It's actually done, the jurisdictions are sorted out by county. So if you're a plaintiff, you have to figure out where to file. And that's done through the Squabble system, or you can do it on your own by getting some assistance at the courthouse. But you have to figure out, okay, what's my jurisdiction? That's a county. Within that county, there are different potential courthouses and different forms to fill out, depending upon that jurisdiction. Some states are more uniform, so they've passed. There are standing orders from their Supreme Court. It's like, hey, we want every county to use this form, which is nice. But to someone who's owed money, we just don't want you to care about any of that. We want you to think, all right, this is just done for you. It's done properly. It's done professionally, and you won't have any problems down the road. Given the fact that it is county-based and there are jurisdictional differences.
Right. Well, thanks so much for sharing all those tips and telling the story about how Squabble was formed, because it's scary if you know nothing about it, right? And it may be even scary if you try to do it by yourself. But it's great that you guys removed the friction for people who were considered it to be too daunting to even do.
Absolutely, and I'm excited to learn a little bit more about how what types of folks in the marketing industry could potentially benefit from something like this. So I really appreciate your time today, Kevin.
Thanks, Michael. We'll talk soon.
Okay, sounds good.
Kevin Lee's Power Marketing is available on all your favorite podcast networks. Kevin loves helping businesses excel at marketing. Having marketing challenges? Just like Santa in the Miracle on 34th Street, if Kevin can't help you, he'll know someone who can. Find him on LinkedIn, subscribe, or follow.